Our next panel is going to be amazing. It's the SEC's focus on, the SEC's role in cyber, AI, and emerging technology, meaning rulemaking, disclosures, and enforcement. And we have a superstar panel that is going to be discussing these topics, starting with my friend, Amy Jane Longo, partner at Ropes & Gray, who will be moderating the panel. Shannon Eagan, partner at Cooley. Sarah Mallett, who's a partner at Kirkland and Ellis. Susan Resley, a partner at Morgan Lewis, and then Madiha Zuberi, who is our resident expert from the SEC from the Cyber and, actually remind me what the name of the thing, Cyber and Emerging Technologies Unit. Okay, got it, okay.
Thanks, Jen. Hi, everyone. Glad to be here with you all today. I think we have a terrific panel, and I want to say I know a lot of our panels today are going to talk about the uncertainty with the new administration and what the priorities will be. I think uniformly people believe that cyber and AI will both remain priorities in enforcement going forward in the next several years, so we're glad to be able to address that. And I think that's for a number of reasons, right? Because it's an area of such enterprise risk and an area for the SEC that really cuts across all the different kinds of registrants, whether it's BDs, IAs, public companies. Just to give folks some context, a recent study by BlackFog indicated that in terms of ransomware attacks, in the first quarter of 25, there was a 45% increase over that same number in the first quarter of 24. So really an area that the risk just seems to continue to grow. And I think with artificial intelligence, generally viewed as something that can kind of compound the risk of cyber attacks, right? The potential for such kind of attacks to be scaled by the operation of AI technologies. So we're going to talk today about some of the recent rules in this space, what some of the enforcement has looked like under those rules, some of the proposed rules that might still be uncertain, and some of the case law that's important here and some key takeaways. And we're going to start with having Madiha talk to us about the new C2 unit, as I understand it's loosely called. And Madiha, why don't you start by giving folks a little bit of an idea of what are the unit's priorities? What is it operationally? Tell us what we ought to know.
Thank you so much. Good morning, everyone. It's nice to see some people in person that I've never met before, so thank you. So my name is Madiha Zuberi. The C2, just to give some context and some background, so originally the cyber unit was founded in 2017, and then there was a crypto assets and cyber unit that was founded in 2022. It formed into that. And then early this year in February, we reformed into the Cyber and Emerging Tech Unit, which I also find challenging to say sometimes. And so that does replace the CACU, the Crypto Asset and Cyber Unit. Currently, we're about 30 specialists across all the offices, the regional and home office. It's comprised of attorneys who are industry experts, as well as data analysts and accountants. And some of the stated priorities currently for C2 are, we're going to be looking at fraud committed using emerging technologies such as artificial intelligence and machine learning, use of social media and the dark web, false websites, hacking to obtain material non-public information, takeovers for retail brokerage accounts. When it comes to blockchain and crypto assets, we're going to be looking at the fraud. And then for regulated entities, compliance with cybersecurity rules, and then public issuer fraudulent disclosures relating to cybersecurity. So that's sort of the broad overview. I think we're going to talk later more about the specifics, and we can talk more about that.
Thanks, Madiha. Is there anything practitioners or companies ought to expect in terms of the operation of the new unit or sort of the trends that we'll see over the next few years?
Yeah, I think, we are looking at fraud, like I said, especially in this new area. I know we're going to talk more about artificial intelligence, AI, but I think, some of the recent cases that have come up, give a sense that we're looking not just at public companies that have been around, but new companies too. There was a recent complaint we filed in April against a startup. And so I think with new emerging technologies, we are trying to be flexible. And I think that's something that companies need to think about even early on in seed rounds, and and how companies disclose what their technology is.
Yeah, that's a great point. So we're going to switch gears a little bit now and talk about some of the amendments to Reg SP that took effect about a year ago. Reg SP, the rule that governs how firms protect and deal with customers' information in cyber context. And so, Sarah, do you want to kind of lay out what the amendments require and what the experience has been like?
Yep, happy to. I do want to offer Madiha the chance to give your standard
Yes,
disclosure
thank you.
if you'd like to.
Before I get zapped by somebody from SEC, no, just wanted to say, you know, my comments today are provided in my official capacity as senior counsel in the Cyber and Emerging Tech Unit. In the Commission's Division of Enforcement, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. Thank you, Sarah.
Of course.
Good catch.
Okay, amended Reg SP. If you haven't had your coffee yet this morning, I'm sure the excitement of this rule will wake you up. So roughly a year ago, amendments to Reg SP were passed. It is applicable to broker-dealers, registered investment advisors, and registered funds. There's two primary components, kind of a safeguards rule and a disposal rule. I'll focus on the safeguards rule because that's where the real meat is. It requires the covered institutions to adopt written policies and procedures for protecting customer information against unauthorized access. It also requires covered financial institutions to provide initial and annual privacy notices that disclose all the ways in which they share customer information. And then thirdly, and probably most importantly, it has a notification requirement in which customers have to be notified in the event of unauthorized access. I might just double click on the customer notification aspect. So according to the amendment, the covered institutions must provide notice as soon as practicable, but not later than 30 days from becoming aware of any unauthorized access, or in the event that they believe unauthorized access was reasonably likely to have occurred. So that's probably going to cover every scenario if you have doubts about unauthorized access. Notwithstanding, though, covered institutions do not have to provide notice if after a reasonable investigation it has been determined that sensitive customer information has not been used in a way that would result in substantial harm or inconvenience. So quite the standard there and the nuanced navigation for no customer notice. But that's the kind of basics of Reg SP.
And I think your emphases there kind of previewed this issue, but what do you think are some of the challenges for folks as they try to put this into place? I would double click on reasonable investigation and also sort of the as soon as practicable, right? Because a lot of times we know in these situations, it's very fast moving in terms of understanding what actually has transpired. It's challenging to get your arms around that, and meeting that sort of standard is not always easy, as I think we're going to hear through a theme of many of the issues we're going to be discussing.
Yeah, I think that's right. And I think, there's nuances of the rule that are difficult, but in talking with clients just at a macro level, it's just one more rule or reg that's entered into the matrix of trying to understand if this happens, then I have reporting obligations under all of these sets of rules. If this situation happens, maybe it's another mix. And so I think just the harmonization that firms are struggling with, what's required under GDPR, what might be required under the Bank Secrecy Act. Do I have reporting obligations pursuant to CISA? What's NYDFS doing, right? And so it's just kind of adding to that regulatory overload. At the same time, I think firms are really getting geared up for it. Compliance dates for the large institutions, RIAs with 1.5 billion assets under management, comes up at the end of the year in December. Smaller firms have a whole nother year.
And do you have thoughts about how firms might, as it takes effect, test how they're complying with the rule? Welcome anyone to jump in here, Sarah.
Yeah, I don't know if anyone else has other thoughts. So I think one thing that that firms are particularly focused on is the broadening of customer information. So in this amendment, it's not limited to a client relationship. Customer information is broadly defined to include any customer information from other financial institutions. And so really locking down all the ways in which an entity has a flow of customer information and what they touch on. I think it's working with consultants and law firms to understand what their plan is, what their notification will look like, what's going to be required, and then there's looking towards how compliance will be tested, which I do not expect, unlike the prior administration, that weeks within the rule being having a compliance date, that there'll be a enforcement sweep. I think it'll be tested in exams. I think people are already seeing a lot of exam scrutiny and focus on cyber readiness and cybersecurity, and that'll ramp up after this next year's compliance date.
Yeah, agreed. I know there were some other proposed cybersecurity rules for IAs and funds. I think they haven't technically gone away. They've been in a proposed state for quite some time. Curious for your expectations if those will ever come to pass, if we've seen the end of them. I'm sure we could take a pool and people would have a lot of different views, but.
So I welcome other views as well, but the proposed cybersecurity rule for investment advisors was criticized by Commissioners Peirce and Ueda, and they are now part of a very important trio with Chair Atkins. So I do not expect that proposed rule will pass in its current form. Could it pass in some sort of other form? Maybe. Cybersecurity continues to be, I think, an important concern for the agency, but more importantly is an area of concern for Main Street and retail investors. They want to make sure that the firms that they're interacting with are cyber ready, and that most importantly they get truthful and accurate disclosures in the event of an incident. But if I was to enter the prediction game, which is a dangerous thing to do, I think that Chair Atkins would probably focus his rulemaking firepower on areas of capital formation and maybe not pick up this proposed rule.
And I think, one could imagine an action could be brought for a fact pattern that might have fallen under such a rule if it took effect, but that could equally be pursued under current law. Of course, I think people wonder if in this administration that's likely to come to pass or not, as cybersecurity policies and procedures lapse as sort of a generic policies and procedures issue.
I think that's right. I think there's a lot of rules on the books in the Advisors Act and elsewhere that would allow the SEC to take an action and communicate to the market about what they think is appropriate or not, particularly from a disclosure standpoint, in a particular like egregious fact pattern that touches on cyber.
Yeah. Well, let's talk about some of the rules that have come to pass. We know in the public company space, we've now had some experience with the rules that took effect previously. And Susan, just to kind of set the stage, do you want to highlight for folks the key provisions of that? And then we're going to talk about what people have seen kind of dealing with those public company cyber rules of late.
Absolutely. And Amy, what you're referring to is the July 2023, and it was the Cybersecurity Risk Management Strategy, Governance, and Incident Disclosure Rule, which that's a mouthful. And it went into effect in December of 2023. And, a lot of comments prior to that, but the upshot of it is there's really two key takeaways if you look at the rule. The first is a disclosure requirement surrounding board governance and really information governance. And what is required is for companies to describe their board of directors' oversight of risk from cybersecurity threats, as well as management's role and expertise. And it's a little bit different than what had originally been proposed, which was there was a proposal to actually have someone on the board, not unlike an audit committee member who has financial expertise. There was a belief that there needed to be a board member who was a cyber expert, and that went away. That's not required. So that is, a company is required annually to make those disclosures about information governance. The other piece, and this is the piece that really continues to be an issue and what we'll be talking about, is the requirement that under Rule 1.05, you have to file, or Item 1.05 for an 8K, a company is required to disclose any cybersecurity incident deemed to be material, and that means You have to talk about the nature, the scope, the timing, how it may impact the company, including financial condition and results. And the key with that is that disclosure has to be done within 4 days of determining whether or not the incident is material. And, to make it even more clear, the rule requires that the materiality determination has to be without delay after discovery of the incident. So it's not a situation where you can wait, 4 or 5 months if it's not reasonable to do so, and then just say, oh, we had this material incident that happened 4 months ago and we're disclosing it now. Materiality standard is the same, but you do have this materiality determination requirement. There is an exception if there's a national security scenario in the AG. You get a specific mandate not to disclose.
And that kind of time period that you're highlighting, that too was a change from the proposed rule, right? What's your sense of how it's working, or the challenges kind of addressing it?
It's really created a lot of confusion. And what happened was that a lot of companies that had cyber risks were putting out what we would call a placeholder of, an 8K that says, we think we may have something material, but we're still investigating. And so it actually caused a lot more confusion than before. And so what ended up happening, as you can imagine, is that there was some guidance that was then provided about 6 months later, first by the former Corp Fin director, Eric Girding, and he published a statement in May of 2024, and he made it very clear that you may not use 1.05 if it's not material. And he did try to provide some guidance as to what was material and what would be immaterial. And some of the things that he said is that, you can't just look at whether or not there's a situation where it's going to affect the financials or operations. You have to look at other things as well, like reputation and the like, and how this affects the company. And there was some further guidance right after that. But what he did say is, rather than filing these placeholders under 1.05, and I'm not a corporate lawyer, I'm an enforcement lawyer, so hearing the different forms and items of 8Ks, what you can do is you file under 8.01, which is different, and that's your placeholder 8K. And what you can say in that is, and you can disclose a cybersecurity incident if it's either immaterial or you think at some point it will be material. So you can make a disclosure along the lines of, we had this incident that occurred, we're investigating it, and that you're at least telling investors what's happened. If at some point in time it does become material, you can then disclose it under 1.05. Shortly after that, a month later, there was an updated compliance and disclosure interpretation, and that provided a little bit more clarity as to evaluating what is material and what isn't material. And one of the things that it made clear is that you look at not just how it's going to affect your financials, but is there a possibility that there might be an investigation, a regulatory investigation, an AG investigation relating to what happened with cyber incidents. You also look at how this incident would affect you reputationally as a company. Is this something that could really cause a problem with the company's reputation? Is it going to affect customer relationships or vendor relationships? So you sort of look beyond a little bit more than even what a reasonable investor would look at. It's almost like, what would my customers think? How would this affect my reputation? And so that did provide a little bit more clarity. And I think we have seen companies now disclose under 8.01.
Yeah, I'm curious if it's your sense that that's had a big impact on practice, that guidance coming out to kind of give folks a better sense.
It has. I mean, there is still, obviously, the biggest, and we deal with this not just in the cyber world, but materiality, because as anyone sitting in this room knows, the SEC is always going to look at it in hindsight, and shoulda, woulda, coulda, and you have to be so careful in really making sure that when you're making those materiality assessments, you're bringing the right people in. You're bringing in legal counsel. Legal counsel has to be part of the process. And I will tell you about one situation, and it's public. It involved AT&T, and it actually didn't result in an enforcement action. It was Corp Fin, but Corp Fin actually ended up making the materiality assessment. So what happened was, and I'm not sure the timing of when the disclosure was, because it was, as I understand, the comment letter was in July of 2024, so query if it sort of crossed when there was some further guidance. But AT&T put out a disclosure under 1.05, which is the one you're supposed to only disclose material events. And the disclosure said, well, we're still thinking about it and making a determination. They got a comment back from Corp Fin that said, oh no, you shouldn't have disclosed this in the way that you did. But guess what? You now have to amend your disclosure and basically treat it like it's material. How much was, what do you know right now? Was there, what was the PII that was taken? Who were the attackers? How does this affect you? How does this affect you reputationally? So, again, you just have to be very, very careful. And it's so important. I can't underscore enough how important it is for legal counsel to be involved, because there have been enforcement actions where you just have the tech people, the CISO and her team looking into what the issues are and making their determination as to, this isn't a big deal, when in fact it really could be. And so that's the most important thing.
And I think one of the challenges here, right, is that if you're dealing with, let's say, a ransomware attack, for example, and trying to assess it for materiality, your information is quite imperfect, right? And the people sort of on the other side of that are not necessarily reliable folks giving you real information, right? How do you evaluate if they say they've got this data? Is that true? Are they bluffing? Are they inflating? Or, is it actually worse than you know? So I think it is a very challenging area for folks trying to get their arms around what's actually happened in those kind of incidents.
It really is. I mean, you're drinking out of the fire hose.
Yeah. What's your sense of whether overall the kind of 4-day rule or provision is thought to be helpful for investors trying to look at this? I mean, on the one hand, the more common these attacks are, right? Does the investor market become sort of numbed to them, right? Like it's not necessarily a shock, right? You saw the one with the telemessage was reported this week, and they're everyday occurrences.
I think that's true. I mean, I think when this really became a hot issue was, I think when Target was hit, when you had just really big breaches and you were learning about them for the first time. And I do think that, it's not as, I don't want to say it's not as big of a deal, because you certainly still have, if you have customer PII, that's a huge thing. But I think investors recognize now that every company is going to be victimized in some way by a hacker. And it's a question of how big the attack is. And I do think, the 4-day rule doesn't mean you have to disclose it 4 days after that attack, but it does impose at least some diligence in trying to quickly get to the bottom of things so that you can make a materiality analysis. And I've had situations where you finally determine, after you dig in a little bit more, after a week or two, this isn't really that big of a deal after all. It didn't, the crown jewels weren't taken, if there wasn't PII that was taken, and so it's not something that would need to be disclosed, where you initially get the call and the first reaction is like, oh no.
Yeah. So Shannon, let's now switch gears a bit and talk about some of the enforcement activity in this area, right? And maybe we can start with SolarWinds, obviously one of the more high-profile enforcement actions the SEC brought here. Do you want to update folks on kind of where that case stands now, and then we'll talk about some of the other recent cases?
Sure. So for those of you who haven't been following SolarWinds, I'll just sort of set the table. The the background facts are as follows. SolarWinds produces software, and its flagship product, Orion, was used throughout the U.S. by government and private entities. And at the end of June 2020, at the end of 2020, the company publicly disclosed that the malware was distributed as a software update. And the US government called this a cyber espionage and attributed the attack to the Russian Foreign Intelligence Service. The SEC filed a complaint, and they filed a complaint against the company and its Chief Information Security Officer, its CISO, alleging that the company misled investors and customers about known material cybersecurity weaknesses and risks. The gravamen of the SEC's complaint is that the company disclosed vague and hypothetical risks when it knew of specific deficiencies in its practices. And the case is notable for a few reasons. First, it was the first SEC enforcement action with scienter-based charges in a cyber case, and it was the first time charging as an internal controls violation, and it was the first time an individual CISO was charged. There was a motion to dismiss, and a lot of the SEC's case was dismissed. And specifically, the court ruled that the SEC had failed to adequately allege falsity, that the risk disclosures were sufficient to alert the public to the types of cyber risks the company actually faced. It ruled that the SEC's authority to regulate and issuer systems of internal accounting controls does not extend to cyber. And it also found that the press releases issued by the company, the blog posts, the public communications were non-actionable corporate puffery. So the court did allow certain statements in a securities statement to proceed. And those claims essentially involved that SolarWinds made statements on its website about its access controls, its password protections, and those types of things, and that those statements were materially misleading, or at least sufficiently alleged to be materially misleading to investors. In the past, I think, week or two, the company has moved for summary judgment. I recommend, it's an interesting read, essentially arguing that the company did, in fact, implement the policies that it spoke about in the security statement. So we'll see where the court ends up on that.
So what do you make of that in terms of, kind of the potential for future cases in this area? Obviously, it's one district court decision. It's, a very high profile one. It doesn't mean as a rule that all the statements that were charged are sort of per se off the table, although I think a lot of people look at this administration and wonder, if the same case would be brought, next month. What's your take?
Yeah, I mean, certainly this case and others sort of are bridging administrations, right? And I think that when you look at, there were a few settlements that came after the SolarWinds case that involved the same actual malware. And the SEC, even after the mixed results on the motion to dismiss in the SolarWinds case, was able to get these settlements. Now, they're a bit different. They got penalties ranging from just under $1 million to up to $4 million.
And just to be clear, these are settlements with folks impacted by it, right? About their own sort of impact from it, not like the direct victim, but sort of the secondary victim?
Correct, correct. So other companies that had, used this software update, which turned out to be malware. In these cases, the SEC didn't claim scienter. These are negligence-based charges. And I think that that's interesting. Interestingly enough, though, the internal controls piece was still a part of those settlements. But again, look, time will tell, but I don't expect that these types of cases will be brought under Chairman Atkins. I think that the trio that we've talked about, Pierce and Ueda, certainly criticized the settlements coming out of the SolarWinds case cases and accused the commission of Monday morning quarterbacking and using hindsight. And so I don't know that these are the kinds of things that we're going to see.
Yeah, I mean, it's interesting, and I'm sure everyone would agree, though, nonetheless, good things to keep an eye on, right, in corporate practice, because, administrations are short, statutes of limitations are long, right? So I think not fair to estimate that things like statements on websites, don't have to worry about them in terms of these kind of cyber representations.
Yeah, I think that's right, and I think kind of what Gina and others on the previous panel talked about, we know that there are other enforcement bodies out there, and I think we can expect that state AG activity will pick up. There is I didn't know this, there's the National Securities Market Improvement Act of 1996, which allows states to enact their own securities and consumer protection laws. And now all 50 states, 3 territories, and the District of Columbia have adopted some type of breach notification requirements. And when you aggregate this across the states and the territories, this is an active group. The SEC between 2019 and 2023 brought about 764 enforcement actions a year. State regulators together are bringing almost 1,800 a year. So this is not, something that we can ignore. And I think, as people mentioned, where there is an enforcement gap, we may see them step up. I think cyber and ESG are certainly areas where we might see them step up. And particularly with the, in Massachusetts, the New York Attorney General, and in California, we've seen some cases, also Washington, or settlements. In New York alone, in 2024, they reached settlements of $70 million for failures in implementing cybersecurity safeguards. Marriott Hotel was $52 million of that. So we're seeing some pretty hefty settlements coming out of states.
And another gap filler, or maybe someone that typically accompanies SEC and regulator enforcement activity, is the plaintiff's bar.
Yeah.
Can you talk a little bit about whether you're seeing an uptick in cases, securities cases involving cyber incidents, that kind of thing?
Yeah, I expect we will. We are seeing, you probably have read some of the headlines, we're seeing plaintiffs' firms hiring heavy hitters out of the SEC, or at least trying to. And in the past, the Cornerstone report, the most recent one, actually had cybersecurity filings falling from its peak in 2021 at 7 to only 2 in 2024. But I think we will see that change. And I think we'll see cyber cases both when, there's a stock drop as a securities class action, but certainly consumer class actions will continue.
And I know some have theorized that with increased SEC required disclosures in this vein, it sort of creates more fodder for potential, the follow-on securities class action when you get a stock drop, right? Because there's more that's been said, or for derivative actions, right? If you're now kind of commenting on the experience of your board, does that become Exhibit A in some future corporate or securities litigation?
Yeah, I mean, in the interest of time, I think we could have a whole session on Caremark and board duties and what is Delaware going to do about these cases. But I would just say, I would expect that if you're having a big consumer class action, or you're having a big, securities case, and it looks like the board was asleep at the wheel or not monitoring, even though this has not, there have been 2 cases that have not been successful yet in Delaware, I think we could see more.
I think that's absolutely right, particularly given the disclosure requirement about, what your oversight is, and your board and your management oversight.
Yeah, and I mean, I think the practice pointer here is continually in Delaware, we're hearing that if you have not talked about it and it's not we know boards are talking about it. If it's not reflected in the minutes, we will assume you didn't talk about it. So I think there's a big swing, at least in my practice, in terms of advice. We used to advise, keep minutes really short, privileged conversation ensued. That's not going to cut it on this issue, and then many issues in Delaware. So I would have more fulsome minute and record keeping.
Yeah, that's a great point. All right, well, let's turn to our last topic, which is a big one, AI enforcement and policy. And I think it would be helpful to start, Sarah, if you wouldn't mind, just sort of setting the stage. When we talk about AI, what are we sweeping in there? I know this conference has had AI panels for, I think, 2 years maybe now. But since we're the first to take it on today, let's just set the table a little bit, and then we'll talk about what the SEC's been doing here.
Sure. So a couple of different standard terms, just the general label of artificial intelligence. What does that mean? It's computers that are being used to mimic human cognitive behavior. That's the simplest explanation. An example, I just saw one this morning, a Waymo car, right? A great use case of robotics and AI at work.
I won't ride in one, but that's just, I'm paranoid. I saw the Terminator too many times. I'm just kidding.
That's your AI at work right there. Machine learning, this is something that's been around for decades, although it's getting better and better. It's a mathematical model that basically trains computer systems to learn without specific inputs. Touches you in everyday life in the form of predictive analytics, both at work and probably at home. It's why Amazon is so good at recommending to you things that you want to and like to buy. And then generative AI, also known as Gen AI, that's the creation of new content based on the training of data. And so that's ChatGPT, feeding the model an input, and then it generates an output.
And I know the commission has been quite busy on this front this year already with several kind of roundtables. Sarah and Madiha, do you want to talk about what's gone on at those? And are there more to come? What should we make of those?
I'll kick it off. So from my perspective and not hers, the roundtable in March and the commissioners who were at that really focused on, in my opinion, AI as another tool for fraud that's unprecedented in scale and speed. So a lot of concern around how AI may be used for manipulative trading practices, how it may be used for deepfakes, how it may be used for cybersecurity attacks or harvesting credentials in other types of ways. And so I think the SEC is laser focused on it and rightly concerned. But the sense I got from the roundtable was that concern was being driven by another instrument of fraud. But
Thank you. Yeah, and unfortunately, we are seeing that as well, in the recent, and if you haven't looked, Chainalysis does a report annually, and they have some good information about that. But I think just to go back to what the C2 is doing in connection with AI enforcement, overall, I would say, we have an overarching focus on rooting out those seeking to misuse this new technology and to harm investors, especially where we understand, this technology, there is a demand for it from customers for AI-driven solutions. And doesn't mean we're just looking at companies or actors who are using AI. We're looking at, whether there's transparency around the technology, whether there is, it's described accurately, whether there's responsible communications to customers. It's easy to use a term like AI, but is it automation of code or is it actually AI as is defined? And so in order to do that, we are getting pretty granular. Like I said, our unit has experts within that we can access as attorneys, and we are talking to the technical people within the companies. And I think, I mentioned earlier, our remit this time with the new unit is to be more flexible. So we understand that there's new technologies coming out. We have internal, universities that we're training in this new technology and understanding it. I think there were 3 cases that I can sort of highlight high level. 2 involved investment advisors claiming to use AI, Delphia and Global Predictions. Those were from last year. And so, if you're really curious to know sort of the specific facts, we don't have enough time, you should definitely take a look at what the disclosures were and how granular we were in our concerns about what the disclosures looked like. And then recently there was a case involving an online purchase AI tool from a company. I think the case is SEC v. Sanager, that we just filed a complaint this April. And there, they claim to be using a fully driven AI online purchasing tool for customers, where we've alleged that there's a lot of manual processes in place. So again, disclosures are important, and I think even new companies need to realize that.
Yeah, and I'll mention for everyone's benefit, there is a nice collection of sort of resources on the conference website that we've pulled together about cases in this area. And there is another April case, the PGI Global, that is a fun read in this space. It's sort of a worldwide alleged Ponzi multi-level marketing scheme. SEC and DOJ both brought cases. It's got Lamborghinis and Louis Vuitton, but it's sort of, to me, it touches every button. It's a crypto, but it's AI and auto trading, so kind of hits a lot of the buttons we've been talking about here. I'm curious for your thoughts on kind of where enforcement in this area is going. I feel like a lot of the cases so far are about this AI washing concept, right? The idea that people are basically just lying about how they're using AI or negligently misrepresenting, allegedly. But curious for your thought on what is the next gen of kind of cases here, and does it get into more, is it conflict of interest, or sort of how it's being used in a substantive way that's having an impact, as opposed to focusing on what's being said about it?
I think it's that. I mean, it's making sure that the investors are protected in an area where there's a lot of excitement, but there may not be a lot of understanding on the underlying technology. So I think we are definitely looking at the technology that way. Some of the areas that I think coming up, you talked about predictive analysis in investment advisory, for example. That may be a use of AI that we're seeing, or AI-based trading algorithms, and the concerns around regulatory frameworks for giving advice, investment advice using these tools. And then, of course, chatbots, and then LLMs, or large language models, and what's being communicated to customers. It is a lot around disclosures, I think, because especially as it's a newer technology. So I think that's...
Yeah, and another area here where, there were proposed rules, the predictive data analytics rules that a lot of folks provided comments on and ultimately didn't come to pass. But an area still where likely existing rules provide, avenues for enforcement just as applied.
And I think also I'd be remiss not to say, as it comes to blockchain and crypto, we're still looking at retail fraud and fraud actors in that space, because we want to make sure we weed that out of the space, and then continue to foster innovation and growth in that.
Of course. So Shannon, is this an area where we've seen the plaintiffs bar kind of keep pace in terms of securities class actions and the like around AI?
Yeah, we're seeing cases that fall in kind of 3 buckets. The AI washing, which we talked about. Cases involving sort of the downplay of the impact that AI could have on, a company's business practices. And then sort of, I would just say, good old-fashioned securities fraud cases where there's some form of manipulating the financials, either by understating the AI research or its costs or its development. The earliest AI cases in the securities class action context were brought in 2020. Since then, there have been 38 AI cases filed, and the number of AI class actions more than doubled in 2024. It was at 15. So we're seeing an up and to the right. The other thing I'll say, and then we'll wrap it up, is these cases are not settling at the same rate. And so they are frequent and also going longer. So maybe that's because everybody's excited about them, or maybe because more's involved, but to be determined.
Maybe people think they have jury appeal. I don't know.
Maybe.
All right. Well, thank you, panel, and I want to thank Brittany Royce, who's in the audience, one of my colleagues who helped us pull
Thank
these
you,
materials
Brittany.
together.
Yes.
And thanks everyone for your thoughts.
Thank you.